Myself, Dr. Tanzim Fatima, ex-faculty of law, assistant professor, faculty of law, IMU, and now as a president, I worked in NGO, Bhrashtachar Virodhi Morcha. Today, I just want to welcome Rajeev Sarji, Bhavna Nigam, and all team of SRF to organize such a good lectures for the academician and all other those they are interested to listen all these type of things. Today, the topic assigned to me is human rights and constitution and overview. As you know, this topic was very wider connotation. And it is not in a half an hour or 1 hour lecture to just point out all the things about rights, human rights, constitutional rights, or whatever envisaged in every document, other type of rights, political, social, economical, etc. First, I would like to say about what right is. According to jurisprudence, if you see social jurisprudence, analytical jurisprudence, any type of jurisprudence which is taught in law, right means claim, interest, anything which is allied or associated with duties. That's why I choose that topic, because if you born, rights start from your birth and extend from your death. Once you be born, you have so many rights. Even sometimes exceptionally, you have some rights which is after death. These are the funeral rights and the other rights like execution of will, etc. We are not talking all this. But here we just see what right is. अधिकार क्या है? और अधिकारों का हनन हो तो उसके लिए what remedy is given by Honorable Supreme Court, High Court, and what type of cases in which landmark judgments given by our various jurists. So my contention here, not to go or just rewrite or read out what written in the Indian Constitution, Article 12, directive principle, and so forth, fundamental duties. Then UDHR 1948, Universal Declaration of Human Rights, gives 30 articles, which is for the reaffirms faith in fundamental human rights. Every human being has rights. I may not read out. Hello? Hello?
Hello? जोटा थिला
सर प्लीज अपने स्पीकर ऑफ कर लीजिए
पानी दबक रे ना कोन कहू
हेलो
नहीं दबक पानी
हेलो
हेलो
हाँ मैम एक सेकंड में इनका म्यूट सर प्लीज आप अपने स्पीकर ऑफ कर लीजिए
हेलो Can I speak?
Yes, ma'am.
Okay, beta, please don't disturb my mind extra to that because I just give lecture, not reading from anything.
Please.
Okay. Yeah, which I am saying here, UDHR, Universal Declaration of Human Rights, reaffirms faith in fundamental human rights. Human rights means every living person has right. Not only the human being, even the birds, in the wildlife animals, even the vegetation, flora and fauna, everyone has rights, because if you say right, that right exists to every living thing, not only the human being, not only the wild animals, not only the birds. So if we see right is claim and interest, which is protected by law, and under Indian Constitution too, we are very much just be taken up everything from UDHR. Like our Indian Constitution, all fundamental right, directive principle, which is just whatever we have in the Universal Declaration of Human Rights. And their preamble says reaffirms faith in fundamental human rights. And here our preamble what says, Indian Constitution, we the people of India solemnly resolve to constitute India, constitute sovereign, socialist, secular republic to secure all its citizens what? Justice. That is social, economic, political. That is also justice is what? It is postulate of rights. It is what? It is dictum of rights. These are, if we just bifurcate or just cut down things in justice, this social, political, economical, this is also part of right. That's why if we see UDHR, here all the social, economic, political covenants, these also allied by the UDHR. All Bill of Rights. If we see way back, Magna Carta 1215, the history, all Vedas, all Manusmriti, every dharma, whether it's in Vedas, whether it is in Quran, everywhere there are certain type rights, time to time given to the living creatures, to the human beings, to the humans. So here we say our preamble 2 with like UDHR, preamble says reaffirms faith in fundamental human rights. Here we also see justice, social, economic, political, and liberty. What liberty? Liberty of thought, expression, belief, faith, etc. Equality, equality of status. There is no discrimination between sex, no discrimination between anyone. Law is same for everyone. If you deny justice or denial of right or denial of human rights, denial of political right, denial of economic right of any person, you can get remedy lies itself in under Article 226 of High Court and under Article 32 of our Supreme Court. And later on, this is also developed by some of the very good judges like Justice Bhagwati and all. So my emphasis, human rights and Indian Constitution overview, it's a very wide topic, but I just say what right is, what human right is, what UDHR, what Indian Constitution, fundamental human rights, what preamble says, and then I just make an analogy of these human rights, all sort of rights in light of various case laws and in light of the judgment, very renowned judgment by our classical jurists or our learned jurists. Because this topic, as I told you many times, it's very wide. I cannot be assimilate in half an hour being a teacher of law, ex-teacher of law. And even for layman, I may say, rewrite these articles, Article 12 onwards, all fundamental rights. They are right to equality, right to movement, right to personal liberty. All these things are your rights, which is also in the UDHR 1948. We have rights. Every human being has rights. But these rights is, although unalienable, it is not transferable. It is recognized by law, justified by law, but still, until and unless any right that don't have remedies, it is useless. It's on paper. It is just like animal existence. So for the rights, what human rights you are pertaining, you should enforce that right. Here we are just see many case laws. Particularly, I would like to quote first Justice Bhagwati. Justice Bhagwati is a man of a number of judgments given by Justice Bhagwati in our jurisprudence. Not only the social jurisprudence, not only the constitutional jurisprudence, not only the environmental jurisprudence. He was given number of judgments which enhance the concept of these rights, human rights, and the remedies, which is in 32 Article 7, which is applied to Supreme Court, and 226, which by the High Court. There are a number of cases given, judgments given by Justice Bhagwati. I just want to give two judgments from environmental law. One is rural litigation case and IMC Mehta. Here, in rural litigation case, entitlement case versus Dehradun, in this case, some limestone quarries, they are creating imbalance, ecological imbalance to environment. In that case, that's why we say Justice Bhagwati Green Bench judge create environmental jurisprudence. He says under Article 21 of Indian Constitution, right to personal liberty, in which it's some procedure established by law. Before this, there is due process of law. So whenever we talks about procedure, procedure you should follow for everything. If you commit any wrong, there is some procedure to follow and get judgment or get justice to retain your human rights. So Article 21 in a broader horizon implemented under environmental jurisprudence, number of cases which protect our environment so that we should have right to livelihood in a good environment, in a safe environment, in a clean environment. That's why many judgments given by Justice Bhagwati in environmental jurisprudence give impetus to the dictum of justice. We provide good environment, clean environment. That's why if you see recently this Noida Twin Tower collapse here, which causes what? It is the judgment given by the Green Tribunal. Just to collapse that because it create imbalance or it is harmful for the person those are living in that vicinity. If you are living in such a vicinity which is not provide you a safe, clean environment, then you hit your fundamental right, that is right enshrined in Article 21. If you hit that, you cannot follow the procedure established by law. That's why another judgment, if you remember, it's of Maneka Gandhi versus Union of India. It is also a very good judgment. In that judgment, there is clearly Supreme Court says that you should have fair, reasonable, and just procedure. Even if any person is detention, if you are free human beings, we are living in our home, you have every type of freedom. But if you are in detention, you are under clutches of law anywhere, you should also have some rights. That's why one of the important judgment given by Justice Bhagwati, Hussain Ara Khatun versus State of Bihar. This is also regarding article ambit. It's just enhanced or ambit of Article 21 of Indian Constitution, which reaffirms your human rights in a broader connotation. That what? It gives speedier justice to the person who is behind the bar. That is very important case in which you say right to personal liberty gives right even to the person in detention. You cannot suspend right. Only fundamental rights you can suspend in national emergency. But as such, you cannot. That's why I also quote, as I just say about Justice Bhagwati Green Vengeance, environmental jurisprudence grown up by him. You see, one of the important things by Justice Bhagwati and other things which you see in number of cases is like, besides safe, clean, and this sort of environment, this Environmental Protection 1986 Act definition about environment, if you see, that gives all living creatures. Here, all living creature includes not human beings, all birds, animals, etc. You have right. And also I earlier said in my starting, diseased and the person who died have some rights after even death. Although these are popular dictum, once you born, you have all type of rights. And once you dead, you cease this for that. No, sometimes you have some exceptionally, you have some right, which is by after even by your death. Here you see that in all living creatures, I just talk about environmental jurisprudence here because Justice Bhagwati, many of the judgments regarding gives right to personal liberty, right to life under the pretext of this green, clean, and safe environment. You cannot be living in environment which is polluted. Like today we have seen pollution level increase in Delhi, in all Gurgaon and all Noida and all these places. Here, this is the violation of fundamental rights of any human being. But if it is causes by any terrorist, if it is causes by factory, if it is causes by anything which is near to you, any factory is just like in Calcutta, there was leather industries that pollute Ganga. That's why you can make PIL, go for court to get remedy under Article 30 of Indian Constitution, Article 226 of by High Court, And that 32 writs, 4-5 types of writ, mandamus hai, habeas corpus hai, certiorari hai, quo warranto hai, etc. You have many writs to impose or get benefit from to implement your human rights. Justice Bhagwati further gives very good judgments by giving broader or just enhance the scope or ambit of Anglo-Saxon period dictum ki when the victim goes to court and any aggrieved can goes to court and get benefit. No, now any person, if anybody is indigent, don't have sufficient means, anyone can, any NGO, any other person will go, state can go and give redressal to him or her for their violation of their basic fundamental human rights. Whenever we say basic fundamental human rights, it is you should provide them by these remedies. That's why Justice Bhagwati has given the concept of public interest litigation, a class suit, a representative suits, all these things are what it is just not we traditionally now bound. Now any person can move court in behalf of the aggrieved or the victim. So here we have number of legislation, not only Indian constitutional, not in UDHR, not Bill of Rights and other. There are number of things, number of legislation which is passed time to time to give right to personal liberty to everyone or reaffirms faith, fundamental human rights as said in UDHR, or give imposition of fundamental by giving the remedies to that. And remedies by the application of writs, Article 32, or by these PIL and representative suits and class suits, etc. That's why we are saying whenever violation of human right takes place, you will go to court and court will follow the procedure, which is whatever is established by law. You cannot be, if you are giving, like sometimes there are cases, you are not providing counsel and the judgment given by the courts. Previously, there was happened these are types of things, but now it's stated you should provide litigant counsel. They will argue their case if anybody is indigent, poor, or not able to have or take or hire lawyer. Then in that case, without lawyer, without following due process of law, without following procedure of law, you cannot decide suo motu that case. Now I would like to give some case laws. I may not define the facts of the cases, this and that. I just give you some cases like D.K. Basu case versus State of West Bengal. It is 1977 probably case, 1987 citation. I might be wrong, but it's 1987. Then Hussain Ara Khatun, I already give you State of Bihar. People Union for Civil Liberties versus Union of India. Then Rudul Shah case, Neelabati Behra case, and number of cases which is judges say something. For what? For the remedial fundamental rights under Indian Constitution. That enumerated and guaranteed fundamental rights will be more than people type, more than the paper tigers. It should be effective by way of amendment, by implementation, by any form. You cannot deny anybody's right, anybody's basic fundamental rights, which is enshrined either in Indian Constitution or any law. Any law. I just quote that there was case, it's of a very famous case, Vishakha versus State of Rajasthan. It's case of sexual harassment at workplace for women. In that case, there are many guidelines given by a Delhi Domestic Forum case, many cases relating to rape, and they define under criminal law 376 and other amended definition of case laws after that Delhi gang rape case, or popularly known as Nirbhaya case. And after that, full-fledged sexual harassment workplace for women ke liye legislation was passed. But here, my contention, and that time that when Nirbhaya case was in Delhi, or Delhi gang rape case, after Vishakha's, it was the case which is create hue and cry in everywhere. Everywhere create hue and cry. And that's why 3-member judges committee was made. Retired Judge Justice Vama, Sujata Manohar, Justice Kripal. These 3 judges, justice, they are in that committee, and that they see what rape laws needs, any type of amendment, needs to repeal something, needs to edit something, or give some wider interpretation to give redressal to the victim of gang rape or rape indeed. So here you can see these are what? These are the rights of females at workplace or not at. If even you are doing something at home, any work you are doing, or by now online culture. Hai. Here emphasis is here not give only you are, when any case came before, you are making committees, passing laws, you see time to time, review that act, review that legislation, whether it truly come out or diminish or lesser rape cases or not. That not needs if anything happens, then you make committees, review and amend and make new legislation. You see that impacts 3 years, 2 years, 5 years, and sumoto makes changes on that. Not when any ugly incidents, any horrible, heinous crimes done or atrocities done to women or to any human being. No. So my emphasis is there we have rights, fundamental rights, constitutional rights, political right, economic right, and there is so many slogans here and there, everywhere. We have number of legislation. Every law needs that jurisprudence grown up by these things, by imposing fundamental. We have remedies already, but still if there is lacuna in procedural, practical compliance, then we are just say it's useless. It's animal existence. That's why my emphasis is whenever, if you have the right, it's duty of not to court. Even laymen should be aware about their rights, so that if something happens with you in starting, you just go and take help or take your solution of your problem legally or by any means. But if you don't know what right, what fundamental right, what your other things which hampers your right to livelihood, right to personal liberty, right to movement, right to equality. Like another thing I would like to say, in many of the cases, there is a violation of Minimum Wages Act, violation of equal remuneration. It is for both male and female, both wages are equal. But if you go, just go any construction site and just visit and see the contractor, what you are going to pay to women and you are going to pay to men. You see the difference. If he is paying 40 rupees to women, then paying 60 rupees to men, what? Why you give? Although they are doing same things, same, but still we are giving what? We are not equally give wages or remuneration for the same work done in the same place. Likewise, many things we are not talking about there, what equality hampers for male, female. We just be concerned about the rights. Rights, it's for male or it's for female or it's for animal, it's for bird or it's for living plants and all. Everyone has rights and it's our duty. Everyone has a duty to protect their rights. Or if you be under pressure or anything, you are like in class suits or public interest litigation, whenever we go in behalf for others, that it should be not for any other interest. It should be clearly you are be with his or her to give justice to him or her, not by you get popularity or media influence, political influence, any type of influence, not. Because law doesn't want that things. It's you are going to help anybody which is poor or don't have means, don't have awareness, So here you should not have any interest, which is that you will just give help, and that help by due following the procedure of law, not by anything by which you get some benefit or by which you get some popularity. That doesn't. So my emphasis is that whenever we are analyzing our rights or human rights or fundamental rights, there are rights always related with duties. That is other discussion point. But here we are not. Whenever you have rights, that right is protected by, in number of cases, judges says that. Like one of the case I would like to say, as per Gajendra Gadkar Justice in Premchand case, AIR 1963, Supreme Court 996. Here the protection and guarantee of fundamental rights for every human beings. Again, in Patanjali Shastri Justice says in Ramesh Thapar versus State of Madras, AIR 1950, Supreme Court 126. Again, in State of Madras versus VG Rao, here they say QY. You should not repeatedly, it's duty of court to grant the remedial fundamental right, not repeatedly, continuously create some problems or erroneous judgment, or you are not following the procedure established by law. So here many cases in many judges, they are emphasized about fundamental rights imposition by remedial measures, and that measures, as I already told, in the writs, all type of writs. ADM Jabalpur case is popularly known as habeas corpus writ case. Many cases there is writ of mandamus applied, in which you can get directions and follow. In other cases, form of, whether it's in form of a vita dicta as a precedent or anything else. These are also point of discussion under jurisprudential thought, under school of jurisprudence. There is a school of jurisprudence, precedent, obiter dicta, ratio decidendi. What? So here, whenever classical judgments, they give some guidelines of similar cases came before court in future, that they are just follow that guidelines to solve the problem. Here, we just not waste time to see again same case and give same guidelines. We just follow as a ratio decidendi, as a obiter dicta, as a precedent, some guidelines given by Honorable Supreme Court and High Court. It is be used as in future cases of similar type of cases which came before court, whether of High Court or the Supreme Court or anything. So here I would like to give some other case laws also regarding enforcement of your fundamental human right. I may not discuss in detail that. I just give you I just quote Ramesh Thapar case. Ramesh Thapar may justice emphasize about that there is no necessity you always go under Article 32 of the Supreme Court for remedial measures. You also go for Article 226 High Court for remedial measure. It is also effective by PIR. In that, if there is violation of your rights, you can go to High Court even. Not necessary every time you go to Supreme Court. So here we are just thought on remedial measures. And my emphasis is whenever there is violation of your human rights, your basic rights, your fundamental rights, your political rights, your legal right, you cannot make just amendment, repeal laws, make new legislation. You just implement it and see the implementation percentage and time to sumoto review, amend or make or pass new legislation for that problems. That's not necessary. There was rape. Crime Bureau reports, if you see about atrocities against women or any type of offense, you will see there is rape if done, sexual harassment is done, any other atrocity is done, dowry death case hai, then you will pass laws. Not necessary. We have already sufficient laws and potential constitutional fundamental rights and procedural laws. Why we not implement it truly? My emphasis is we have very broader connotation of law by the way of implementation also. Sometimes you just not give like pass laws. We have laws by implementation, by interpretation. You just solve out the problem. You have legislation in your hand. You cannot waste your time to make committees or years or months to make another legislation or amend that. Although whenever we need, we can amend, we can repeal, we can add, we can pass. But if we, by making interpretation of laws, solve out some problems, so we will not go for that. Which is also, there are various forms of types of interpretation, liberal, harmonious, many types of interpretation. So my emphasis is like interpretation, say you can solve so many problems or impose your fundamental rights and get redressal by not wasting much time, court ka bhi and yours also, or you cannot waste your money too. So it's to discuss human rights, to discuss constitutional right and overview. My lecture just be on these points: what human rights, what UDHR, what constitutional fundamental human rights, and what are the remedial measures in these case laws, by which we can see the implementation of these fundamental rights, basic fundamental human rights, which is given to us by our constitution as constitutional right, and because we are citizens for this country, so we have this. And as a human right, if you have that, being a human being, you have that rights, constitutional right as a citizenship, you got it. And you, if there is violation, you go for court, it is justifiable by law, it is recognized by law. Unlike directive principle, which is not justifiable by law, not recognized by law, but these rights by birth, by citizenship, we got it. And even human rights, it is what? It is, although allied with these rights, it is as a human you have rights. As a human being you have rights, which is also recognized by your, if there is violation, you can get and go court for the imposition of that. That's why right to equality, right to personal liberty, right to movement, any right, fundamental right. There is violation, you can go and get justice from. Because wherever you impose rights, for what imposition of rights? To get justice, to follow rule of law, to follow principle of legality. You see the principle of legality in criminal law, it's a very good maxim, nullum crimen sine lege, nullum pone sine lege. It is first principle of legality. Principle of legality lies on the pillars of what? It is on where your rights, imposition of right, recognition of rights, rule of law, follow procedure, get dictum of justice, fair, just, reasonable. Ultimately, court justice. And enhance what? Jurisprudence. Justice, justifiable, or the jurisprudence which gives justice to all, gives social recognition to all human beings. So here,
subscribe now and press the bell icon. Never miss an update.